you and want to thank everyone for attending today, for those in person and those who have joined online, especially our speakers for today's workshop. NACO hosts about 4 workshops a year. This is a specific one that we try to do some after the legislative session on specific legislative items. This is one that was brought to us by one of our panelists. They'll make themselves known here momentarily, and on Assembly Bill 211, which is what we're talking about today, which is health and safety receiverships. So I'll introduce myself. My name is Vincent Guthrow. I serve as the executive director here at NACO, and I'll also serve as the moderator. Like I mentioned, today we'll be discussing the issues of receivership, specifically Assembly Bill 211, which was passed during the 2025 session of the Nevada legislature. We'll cover how health and safety receiverships work today. Just want to kind of give you a lay of the land of what we'll be talking about. So we'll talk about from the petition through the rehabilitation and cost recovery process, along with tenant protections, relocation requirements, and some lessons learned and some real life sort of case examples. We'll also explain the new authority provided under AB211, which took effect on October 1st of this year, just recently, or of last year actually, which allows local governments, including counties, to use this tool to address severely substandard properties when our traditional enforcement efforts have failed. We would ask that you maybe hold some questions till the end. I think maybe give the presenters some time to work through their materials and present their materials to you. That might answer some of the questions, but of course, feel free to save those till the end for everybody. Again, I want to thank all the individuals on our panel who agreed to provide you with the information today. But I do want to take a minute to thank Assemblymember Considine, who sponsored AB 211, for joining us this morning as well. We have provided, and we'll email that to the folks that are online. We provided a handout. We used to sort of go through this lengthy process where we sort of outlined everyone's bio, but we hand that out. So and that will outline everyone's sort of impressive bio that brings this sort of panel of experts today before you. We also included a brief summary of AB 211, the legislative summary, and a contact information for each of our panelists as well. Before we go into our presentations this morning, I just wanted to provide just some housekeeping items. If you're on the computer, please mute if you're not speaking. That way it just cuts down on background noise. And also just side conversations in the room, just because the microphones, as I mentioned earlier, are live. And then just mute phones, of course. But we'll take questions, as I mentioned, at the end of the presentation. Participants are encouraged to provide input and then ask questions from the attendees, of course. We have a plan today to go from 9:30 to 11, of course, with some leeway there around questions. Finally, NACO has a pretty robust website, and we post all of our workshops and all of our resources and all of our learning material on that website. We will record this workshop. It's being recorded right now, and we will post that on our website. So if there was someone from your county or someone from a county department or another elected official who was interested in this topic today but was unable to attend, let them know that these resources will be made available and uploaded to our website. Unless anyone has any questions about the housekeeping items, I will turn it over to Assemblymember Considine if you want to get us started and just sort of give us. I think we're going to start off with the legislative intent and sort of the legislative overview of 211. So if you're ready for us, we're ready for you.
Sure. Thank you so much. Can everybody hear me okay?
We can hear you.
Perfect. Okay. That's like the statement for Zoom overall all the time. So anyway, my name is Venetia Considine. I have the honor of representing Assembly District 18, and I was also the chair of government affairs this past session. Housing has been something that I've been working on for essentially my entire legal career. So trying to make improvements in areas where it's fair and equitable is kind of what I focus on. Prior to the session, Joanna Jacob and I had several conversations conversations about substandard housing and buildings and what can and cannot be done to kind of clean up some blight, to have some sort of a mechanism for landlords that are extremely absent, whether physically or financially or in any other way. And the result of our discussions and a lot of work that was done was by Joanna was Assembly Bill 211. And the intent of the bill is to protect and to provide a solution when there's an extreme situation, when a property is significantly substandard and all attempts to bring the property to standard are either rebuffed, ignored, or where the owner is unable to bring it up to code. These are situations, for an example, a specific one was where in a multi-level apartment building, there were seniors, the elevator was broken. So seniors were either trapped in their homes or they were literally crawling up stairs to get to their apartments. And all opportunities to try to get those substandard issues fixed were not being followed through for whatever reason. Or when the owners have determined, in some cases, where paying fines is still more acceptable to them than making the fixes on the properties. So state law, you all already know, landlords are required to maintain a dwelling in habitable condition, and the law delineates violations concerning the health, safety, and sanitation and fitness for habitation. So this bill was specifically focused on bad actors, just the most extreme bad actors. And I'm sure that you all are familiar with this. There's many levels of process provided in there. We did the best that we could to ensure that this was equitable. And also there were several edits and changes made to this bill to make it as acceptable as possible to all members involved. So overall, I think Vincent said it much better earlier in a one-sentence statement about the purpose of the bill. So I might kind of just leave it that way. But and you all know this, but this is something that I say every time I talk about the bill, that this process does not begin with receivership. The process in this bill begins with notice. It begins with opportunities. It begins with, having like a litany of how a county has attempted to resolve this matter to begin with. It's not like an immediate jump to something that seems extreme. And there are also more than 20 states that already do this process in some form or another. So we weren't like the first state to do this. And then I know that this is a county focused, but the bill essentially has a mirrored portion for the county and for the city. So I hope that kind of covers the intent. And if you have any questions, I'm happy to answer them. But truly, Joanna Jacobs is the one who kind of did most of the work on this. So I'll leave a lot of that to her. Thank you for your time and thank you for bringing me in.
Joanna, since the assembly member teed you up, do you want to go next?
Sure. Sure. I actually didn't ask her to do that, just for the record. It was actually a joint effort with Assembly Member Constantine, who sat at the table with me for hours while we tried to work out and negotiate this during the legislative process. I'm Joanna. I'm the government affairs for Clark County. And I will just say this was an important issue for Clark and by our then chair, Commissioner Secker-Bloom, because it's one that is specifically impacting his district in addition to several other commissioners in Southern Nevada. And I can go through the assembly member noted like the amendments that we did during the legislative session. I think it's important for everybody to understand. I get questions a lot at the county, like why does the bill come out this way, or why were these limits put in? And so I want to just note that for the county people who are trying to implement this bill and think on how to implement it and under which circumstances you may want to use this. Or I will also note that you don't have to use this. This is not a mandatory tool or mandated in any way from the county, but it was meant to address some very specific issues that we have seen. I know from our conversations with legislators that this is an issue that at least the legislators felt it was statewide, that many of our county and city elected officials are seeing this in their district. And so I'll go through some of the limits that we put in place, and then I'll hand it over, Vince, to our speakers today. But this is one of the things I want to emphasize for us in Clark County. We have not done one of these receivership petitions yet. We are still working about the notice, and that this is only after traditional county processes. When I talked to my code enforcement director yesterday, he said this is where Clark County has an abatement budget, and we are a lot of what we existing process and our abatement process. But one thing that we don't do in code is rebuild. So we can abate till the cows come home, but then that was one of the things that we found that was a hole in the law, and this is where the receivership can come in. We faced a lot of concern during the legislative session, I will say, just about you see Vince alluded and Assemblymember Constantine alluded to restrictions. We felt we wanted to start with multifamily rental apartment buildings. That was where we were seeing a lot of the violations in Clark County. And this was one of the negotiated terms that we did in the Senate. There were concerns about this was not going to apply to single family homes dealing with noxious weeds. So, this is something that this is where we're doing this, where we have tenants involved and where people are paying rent. And then there are conditions that are really substandard and very specifically tied to where there's substantial endangerment to health and safety of the tenants that are living at the property. We put in additional notices. So for Clark County, the property that we were trying to fix is one that is very known to our code enforcement whole entire staff, that we've been working with this property for years, trying to get abatement. They took rental assistance during the COVID, and then we've just seen over and over repeat violations. And that is one that we will still exist. The law was written to contemplate that the process would still be our traditional code process. And then if there were repeat violations and failure to comply, then a notice would be given. One more notice, right? And there would be a county process to try and attempt to bring people into compliance and specifically give notice to the property owner and to all the residents, posted on site, and then also mailed via certified mail to both the property owner and to each resident, that there is a chance that if you don't come into compliance, that this could be used. Then after that is done, then there's a request in there to, again, rehabilitate or to bring the property up to code. And then if there's an additional failure to comply for whatever time frame that the county defines, then before running to the courthouse to petition for receivership, there's a mandatory 30-day notice, also a second notice period. And that was specifically negotiated to make sure that there's multiple levels of due process in this process and opportunities to avoid receivership by working with our code enforcement division. For at least for Clark County, and I know this is true in other counties, our code folks always want to bring. Our goal is compliance. So that's where I will note, we wrote in multiple levels of notice. There's also transparency. The only other thing I want to add on the legislative side for the county folks who are in the room, there's a lot of oversight that our speakers will go into once you are in the court process. There's also monthly reporting by any receiver appointed to the county commission. So the county commissioners can keep an eye on this and see what's happening, at least with respect to the tenants that are on the property, and then annual reporting back to the legislature because they would like to see how this is implemented. And that was specifically negotiated. And I guess I'll hand it over there. Once the notices are done, then I'll hand it over to our speaker, Vince. And then, of course, we're here to answer any questions. Thank you.
Thank you, Joanna. I will, at this point, I'll turn it over to I think I can call him Red Griswold. Red, do you want to take it from here since you have, so Red is going to cover some sort of case examples, talk a lot about collaboration, and he'll take it from here. Red, if you want.
Yes, of course.
right.
Thank you, Vincent. And
thank you.
thank you for having me this morning. And so just quickly, background from my perspective, I focus on acting as a health and safety receiver. It's been my focus for the last just over 15 years now, and have been appointed over substandard properties as a court-appointed receiver over 300 times. So for better or worse, we've seen a whole lot of messes. And I just really want to kind of double down and reiterate what we've already heard this morning, and that this remedy is definitely reserved for the worst of the worst. It's not something that cities or counties should jump to as their first response to any sort of violation or difficult property owner. And that's what I would expect in Nevada as well, is that it's a tool in the toolbox for any city or county, but it's certainly reserved for those worst of the worst from a condition perspective on a property, but also reserved after layers and layers of notice and a reasonable opportunity for an owner to step up and take care of their own property. Because at the end of the day, that's, I think, what everyone would like. Tenants, city and county folks, community members, is that we want owners to take care of their own properties. But again, there are those rare cases where nothing is working. You're not getting compliance, whether it's by refusal by an owner or an inability, whether that be financial, whether that be mental, whether that be that they died. We get those a lot. But when you run into that brick wall, having this receivership remedy as an option and a remedy can be very powerful to clean up blight and unsafe conditions. So I thought I would kind of take it from here after getting kind of the background on the intent of AB211 and also kind of the now passage of the statute and how it reads from a statutory perspective. I hope to shed some light on what I see when this statute is kind of put into action from a practical perspective. And so the first stage of that is really a city or a county. I'll just refer to counties today because I know that's kind of the focus. So this is really a county now putting this into action and taking one of these properties and these property owners to court. So as Joanna gave an overview of regarding kind of the notice periods, I'm not going to speak directly into the weeds on the statute so much, but hopefully I'm going to give color to what I have seen in my experience as to what judges really want to see from a county when one of these cases gets to court, and what kind of factors a judge will be weighing when determining if a property really does fit the bill to have it be put under court-ordered receivership. So we talked a lot about notice, and really the key phrase here is that all owners must be given the reasonable opportunity to correct the violations at their property. So as the statute reads, what that really is going to mean is they first need to get that notice that's laid out, and that notice has to be very clear as to what the violations are. This notice has to address a certain defined time period, a deadline by which these violations have to be addressed and complied with. And then it has to lay out very clearly what then the consequences to an owner if compliance is not reached by that deadline. And so there's the language, but now let's fast forward to once a county has filed their petition, they've got a petition hearing date, and now, counsel for the county is in court arguing to the judge as to why this property should rise to the level of having a receiver take control of it. Most judges are going to be very much keyed in on, well, hold on, this owner certainly has lots of rights. This is their property that they own. did they really get a reasonable opportunity to handle this on their own, like we'd all like them to? And so there's going to be lots of practical issues that will be raised. The owner obviously will be in court. Potentially, they have, of course, have the right to have their own attorney who's going to be arguing and advocating on their behalf. And so there will be certainly questions of, well, how clear was it defined for this owner as to what were the problems at the property? Was it a comprehensive scope of what the county wanted to be addressed? Was a reasonable amount of time given? And I bring that up because that's a common issue that's brought up when these petitions get in front of a judge. The statute, just as it is in California and many other states, here in Nevada, it is also silent as to what the original kind of deadline period is to comply with a county's demands regarding violations. And that's, I believe, intentional because I think we all know that there are certain violations that, reasonably speaking, might take someone weeks or even months to address, whether that's unpermitted work on a property, whether that's, very much involved environmental remediation and demolition. So counties are going to look pretty silly if they run to court and say they gave a property owner, 2 days to demolish and remediate asbestos, contamination on a 300-unit apartment building that's occupied. 2 days is not reasonable. So courts are going to consider what is reasonable under the circumstances. I'll give another practical example, though, on the flip side of that, is that if you have an occupied apartment building and there has been a fire and you have no electricity and you have occupied units with children and elderly folks, and you need this owner immediately to safely relocate occupants and shut down certain units because they're not livable or habitable, now you don't have to give an owner 75 days to address that. We have life and safety immediate issues. And so there may be some immediate deadlines you're going to demand that an owner meet, or else the county is going to take drastic measures. Here may be seeking the appointment of a receiver. So under those circumstances, that reasonable time may be, days, 72 hours. And so there's a lot of leeway there that counties will have to, wrestle with, like they do all the time in dealing with properties gauged on the severity of the conditions, the severity of the health and safety issues for the occupants of the property. I also want to bring up that there's language used in the
I
qualifications
think it
that
works off of the counter. It's his
Yeah.
exemption.
Could you please mute if you're not on? Sorry. Please mute. Thank you.
I was going to key in on a phrase, words used is courts need to determine that conditions at the property are substantially endangering the occupants of the property or the community at large. And that's also important. It sounds obvious, but this is another kind of consideration that counties will need to be wary of. What are violations and conditions that substantially endanger the public? Obviously, I'll go back to that same example. You have a tragic fire. It's affecting, multiple units. Electricity is out. It's the winter. There's no heat. I can go on and on. These are factors and violations that are substantially endangering occupants and the public. Now, you could certainly have violations at a property. You could have weeds too high. You could have some peeling paint. Now, that's going to meet a violation in your municipal code, but by no means is that substantially endangering the public. So that goes back to my first point, that we're only dealing with, the worst of the worst properties, putting occupants in the community substantially endangering, their lives. And so we want to reserve this for those types of conditions. And that's, of course, something that a judge and, of course, a property owner and their lawyer are going to key in on, that we're only talking about violations that are substantially endangering the public. I'll give another kind of practical tip at this stage of, if you're envisioning a county, in court trying to justify that a property should go into receivership. Another thing that judges are always keyed in on is they want to make sure that what the determinations they're making them based on real-time conditions at the property. And so this is more of a tip and counsel I give to when I speak with code enforcement departments and building officials, and also, frankly, district attorneys and county council when they're preparing petitions and all the paperwork to go into court and request a receiver. And the point here is, let's say you've got an apartment building that's in horrible condition, again, failing, sewer system, ineffective or destroyed stairways, elevator doesn't work, etc. Now, let's say this is in, June of 25. And the documents or the conditions are documented, pictures are taken, declarations are signed by the building official, meetings have happened, letters have been written to the owner, all of the notices have been given in the proper timeframes. Yet again, another 30 days notice of intent to file the receivership action. But you know how things go with courts, and by the time they actually have that petition hearing, let's say we're talking, it's today, it's January 9th, and the county's in court, and the county's presenting their petition. And I have seen it 20, 30 times in live court where an owner or their lawyer stands up and says, oh yeah, that elevator issue, we fixed it. And the electricity, no, it's good. Lights are on. Everything's great. And on and on and on. And the judge is kind of now stuck in a position that no judge ever wants to be put in kind of a he said, she said moment, where judge is now looking over at county council saying, did they fix the elevator? Well, and then the judge will ask, of course, the question, when's the last time any of your representatives have been to the property to determine what the conditions are today? And a county doesn't want to be stuck saying, well, I guess it was that, violation report we sent in July of 2025. Now that's a drastic example, but my point here is that I always recommend that, in this particular instance, what counties really should be doing is as they prepare for that hearing is certainly send out, whether it's code enforcement officer, a building official, whoever's most appropriate, to go by the property at least a week before that hearing, if nothing else, for just a drive-by inspection. Maybe take a few exterior photos. Maybe if they do know some of the neighbors and they have, some informal kind of update discussions. And then that code enforcement officer or building official should attend that court hearing, potentially even have a declaration, written up so it's a little bit more real-time documentation of what the real-time conditions are. So there's a couple quick tidbits. Now at that petition hearing, the judge really has two decisions that it has to reach. The first one is does the property really rise to the level of the appointment of a receiver? And again, it's going to go back to, are the conditions substantially endangering the public? And did the owner have that reasonable opportunity to correct those issues on his or her own? If you get over that hump, now we're saying, yes, this property does rise to that level. The court needs to take court-ordered receivership control. The question then becomes, who is that receiver going to be? And so as laid out in the statute, a receiver needs to meet certain qualifications based on experience, capabilities to handle this type of property and this type of project. And counties are allowed to present in their paperwork, A, here's this property, here's why we need a receiver, and B, here's the receiver that we're proposing, here's his or her, resume and book of experience, etc. So the judge then is determining, okay, yes, we need a receiver, and then next question, is the receiver proposed by the county qualified, experience, etc.? Assuming yes, he or she is, okay, now I'm signing this appointment order. So at that point, now that's really the next practical step is if that judge determines that it is appropriate and he or she is going to appoint a receiver, they're going to sign a court order. And that court order is likely going to mirror a lot of the language that is in your new statute in the section that lays out really the duties and obligations of a receiver. So as a health and safety receiver taking over control of the property, it's at that point where really the big old mess, the mess of the property that it is being removed from the code enforcement officer's desk, and it's being dropped on the receiver's desk, someone like myself. So at that point, this order will say that the receiver is now in legal possession and control of the property. Now, it doesn't take ownership of it, of course. Property owner still owns that property, but from a court-ordered legal perspective, the receiver takes legal control and possession. So what that really looks like is, again, we'll go on with kind of the apartment hypothetical, is that at that point, the receiver is stepping into the owner's shoes and really acting as that landlord. So all of the responsibilities and authorizations that an owner would have as a landlord, now the receiver has those responsibilities. So that's dealing with tenants and occupants, that's collecting rents, that's paying for all of the property expenses, insurance, utilities, taxes, and really managing the property ideally in the proper and appropriate compliant way that the county has expected that owner to be managing the property in the first place. Now, depending on the severity of the situation, a receiver typically is going to get out to that property within a day or two, depending on how dire the situation is. But the receiver is going to get out on site, live in person at that property immediately. And the purpose of that initial inspection is super key. So at that initial inspection, what the receiver wants is an in-site inspection with all of really the key people involved in that property. So that's going to be the owner, any representative of the owner, legal or otherwise, that they want to be at that initial inspection. The receiver is going to invite contractors and other vendors that likely will need to inspect and provide potential bids for the rehabilitation work, for potentially, fencing or board up of certain units, different security vendors, any vendor that's appropriate to the conditions of that property that may need to, present some sort of scope of work or bid. As a receiver, I'm always inviting all of the relevant code enforcement inspectors, building officials that have been, tied to that property and that file. And I also invite the owner to bring their own contractors to walk the site as well and present their own bids for the work that might need to be done. And this initial meeting is important from my perspective, as a receiver's perspective, because we come into these cases, we are neutral. We have a fiduciary duty to the court. We're in a sense an extension of the judge on the ground. So we don't work for the county. We don't work for the property owner. We really are an extension of the court. We are the eyes and ears, on the ground at the property on the court's behalf. So in that initial meeting, it's important as a neutral, third-party court officer to start fresh. And to that extent, what I'm trying to do on that first, initial meeting is say, I don't really care to a certain extent what's happened in the past. Let's deal with real-time conditions of this property. Let's re-identify the violations, and let's put together a plan that I'm going to present to the court as to how we're going to resolve these violations in the most swift and efficient manner. It's important for me to have all of the code enforcement officers and building officials on site at that moment, because I'm already going to have all the violation reports, all of the notices that have been given, all the photos of the violations. But it's important for me to identify any supplemental information that might need to be provided. So what I tell counties in advance of that initial meeting is that let's bring your violation list. But I want you to note if anything's been addressed and the owner wants to point to things that they've fixed or addressed, let's all take a look at it. And if in the moment the county can say, yeah, actually they did fix the elevator and it's compliant and it's permitted, etc. Okay, let's cross off the list. Now, in the same vein, I also want the inspectors to be looking to say, hey, we haven't been here in 6 weeks and now we're noticing even more violations. So it's important to note that whatever those violations are that have been presented to the court through that petition, it's not limited to whatever was identified, pre-petition. At the end of the day, the judge is going to order me to get that property into compliance and address all existing violations that are currently on site. So after that initial inspection, I'm having the county provide me, if they need to, any sort of supplemental violation list. So we all have kind of an apples to apples, fresh perspective. Everyone on that inspection roster is going to know exactly what those conditions are. At that point, I'm going to resubmit, that violation list to any contractors, vendors that we are going to need bids from to put together a comprehensive kind of rehab scope. I'm going to invite the owner. If they'd like their contractor to present a bid, I'm more than happy to receive it and review it. And as long as they're licensed, insured, and reputable, they'll be considered like any other contractor that I'm going to invite to submit a bid. Once I have those bids and I've put together, as laid out in the statute, we've put together our plan, our rehabilitation plan, and our proposed budget. I will then go back to court. I'll file a written report in advance of a court hearing. I will share it with the county. I will share it with the owner. I'll share it with any other party to the matter. Allow for feedback from all parties. And then we'll go into court and I will be presenting that plan. And ultimately, the judge will make the decision as to whether or not he or she wants to approve my plan, alter my plan. Again, as the receiver, I don't have any, dog in the fight. I'm trying to gather information, relay it back to the court, and present what I believe is the most reasonable and swift way to get these problems addressed. The court, let's just say, the court agrees with my plan, and it's going to sign another court order and allow for me to carry out that plan, give me the authority to hire the particular contractors and vendors that I'm proposing, and also secure the budget to pay for all of this rehabilitation. So I want to touch on that quickly as well. So as the statute lays out, a receiver is authorized to utilize, of course, any income from the property itself to pay for the receivership budget. So that would look like, a receiver collecting rent from occupants at the property. Now, a lot of times, depending on how extensive the rehab is, the rents from the tenants are not going to be able to cover, of course, all of the normal property expenses. And then on top of that, be able to cover an extensive rehab project. So Nevada law now allows for, through this new statute, the ability for a receiver to borrow money against the subject property to pay for the rehabilitation of that property. So that vehicle is really confirming that at the end of the day, the owner of this property that is in violation is going to be responsible for the costs of getting this property back into safe condition. So how that works, and this is all transparently shared with the court and all the parties and approved by the court, is that as a receiver is able to fund what we call receiver certificates. And that's another name for a private loan, a promissory note. And so these receivership certificates are laid out to be funded by outside lenders with secured against the actual property itself. So as a receiver, it's also my job to go out and secure potential funding if needed from an outside lender to pay for all of this work that needs to be done to this property. So that's going to be part of my proposed budget and plan that I present and get approval from the court on. At this point, I'm going to take a bit of a step back because I did want to touch on occupant relocation. So at that initial inspection I mentioned, another key point in this is that as a receiver, we're going to give advance notice to all occupants that, hey, receiver's been appointed. Here's the role we play. Here's all of our contact information. Contact us anytime for any concerns. And hey, by the way, we're going to be out there for our initial inspection. We'd love to meet all of you and get all your contact information. It's our practice to go door to door, meet with every single occupant, and make sure they know who we are, where they're supposed to pay rent, where they can call for any repairs or emergencies, etc. At the same time, what we're also doing is we're going to inspect every unit to understand the extent of any unsafe conditions. If there are occupants that need to be relocated immediately, the statute allows for that. If, on the other hand, another class of, relocation is going to be folks that their unit is safe and habitable for now, but based on the work that's going to have to be done at a later date, once approved by the court, it's not going to be safe for some or all of the units to remain occupied during the actual construction project. In either event, the statute lays out in great detail exactly, the dollars amounts and the types of expenses and such that can be covered under a relocation budget. And that also would be presented in my rehab plan and, budget plan that would be presented to the court for approval. Now, I'll kind of speed it up a bit here, is that assuming the court gives approval for my plan, then we're going to carry out the plan. That's going to simply be a rehab project at the property. Again, could involve relocating occupants temporarily while the work's being done. And at this point, I want to talk about kind of we noted kind of collaboration, with county officials throughout this whole process. As Joanna mentioned, there is a requirement, of course, that the receiver is providing monthly updates. We call them kind of receivers reports that are filed and served each month. And they are, of course, provided to all the parties, including the county, as well as the county commissioners, as well as any party to the case. And that's going to provide transparent details on all the financial accounting, expenses paid, money in, money out for the receivership, progress of the work at the property, any concerns or hiccups with the project. And it's kind of an ongoing, monthly update for all parties to make sure that everyone's aware and there are no surprises and any issues are addressed in a transparent fashion. Once the project is completed, the county is going to issue sign-off, and that sign-off is going to happen like it would any other project that a county is overseeing from a construction perspective, from a permitting perspective. As the receiver, I'm acting really as the owner in applying for permits, in coordinating with inspections along the way with different building departments, etc. But assume now that the property has been rehabilitated, all the violations have been addressed, and the property is now in a safe and habitable condition. Now we move into kind of what I call phase 2 of a health and safety receivership. And now what that is okay, the issues have been addressed, the occupants are now in a safe condition, and now it's back to the owner from a financial perspective of, okay, owner, what's your plan to address these receivership certificate liens? These are short-term liens. These are meant to be addressed before the receiver is formally discharged and the case is over. So it's really up to the owner as to how that's going to be handled. We see several different outcomes in this realm. Sometimes owners simply say, okay, how much did that all cost? Okay, we'll pay it off. We'll get rid of this receivership lien. You have other owners who say, fantastic, I'm gonna, refinance this loan and pay off the receivership lien. You have others that may Well, they may have been missing from day one or dead, frankly. And so now it's really going back to the court and saying, okay, court, here's this property. There's no, responsible owner that's taking any position here. Hypothetically, we know that this owner died without an estate plan, and there is no probate. And so we'll really look to the direction of the court as to what should happen to this property at this point. And a court has the discretion to authorize a receiver to sell the property. And so, but that needs to be addressed before the receivership is going to be closed out and the judge is going to dismiss the matter and discharge the receiver. So as a receiver, again, a receiver is going to oversee that process and kind of shepherd some sort of resolution that is, court supervised and court ordered at the end of the receivership. I'm trying to be mindful of my time. I know that we wanted to talk quickly about maybe a couple case examples. I think what I want to kind of say to that is I just wanted to point out two kind of categories of where I see the types of properties that Nevada should be able to address through this new statute. As was mentioned, the statute in its final form is limited to only residential multifamily rental properties. That's the kind of defined term within the statute. So, shorthand for that is going to be, likely apartment buildings is going to be the general type of property. Whether that expands in future years is, up for anyone's guess. But for now, that's going to be largely your apartment buildings. And so from my perspective and kind of experience with apartment buildings in California is that they're usually going to fall in two buckets. You're going to have apartment buildings that are occupied by what I'll call innocent third-party tenants. And it just so happens you have a bad actor landlord who is difficult to deal with from a county perspective, refusing to address violations and is willing to kind of fight about it, kind of your recalcitrant property owner. And that's going to fall down the line of kind of some hypotheticals I was laying out earlier of receiver stepping in, meeting with all of these tenants, understanding the extent of the violations, figuring out a relocation plan, and addressing those violations because the owner is refusing to do so, him or herself. The other bucket, I would say, are typical kind of cases we see are going to be, an owner who, again, died or just skipped town and kind of ditched the property. And those are kind of your properties where it could be, frankly, kind of an abandoned apartment building that has just been maybe sitting there for years, maybe decades in a county. And you might have transient activity. You may have criminal activity on site, whether that's, folks kind of breaking in, starting fires, selling drugs, stealing the piping. And it's just kind of a long-standing eyesore blight. Depending on the type of year, you might get some fire issues. And so really the danger is to unauthorized, really trespassers, occupants that are utilizing the space in an unsafe way. But most times you're seeing that the community members that are, again, to go back to the buzzword of substantially endangered by this property, are neighboring properties. So that's where usually counties are hearing the most from. You're getting it from neighboring properties, whether they're businesses or residential, homes or apartments next door, and they're going, how many more fires have to be started inside this abandoned building before our building is going to catch fire as well and cause grave danger? And so that's where I kind of see, Nevada's two big buckets potentially of properties to deal with. You have your your bad actor landlords, where you have a bunch of innocent third-party tenants being affected and in grave danger. And then you have your kind of long-standing eyesores with no end in sight because either the owner's dead with no probate, no estate plan, they've skipped town, or for whatever reason, there is literally no one at the wheel and no one responsible for the property. And it's kind of a ticking time bomb as there's no oversight or control. So with that, I think based on kind of our time, I'm kind of at my time for now, but of course I'm open to questions now or even after the session. Thank you.
Thank you so much, Red. Appreciate that. Now, I'm going to turn it over to Leandra if you want to give us sort of a property manager perspective on this.
Absolutely.
Appreciate it. Thank you again for joining us here.
Yeah, so I am a property manager. I am a lot less to say than these two guys. But I wanted to point out a couple of things. This is a great tool because it's not just large apartment complexes, it is multifamily, which is duplex, fourplex, eightplex, not necessarily just a very large apartment complex. And my practice, I have a lot of out-of-state owners who don't have eyes on the ground, don't know this is coming. If they don't have a local property manager and they've got ongoing issues, this is a great tool. But it's also a tool for us to allow a protection to them, to the tenants and to the out-of-state owners that, you know, if you have someone local that knows this law, we can keep you out of trouble. We can keep you from having to go to the expense of all of this situation going on. One of the things that I think is great is that a manager can walk away. In my bio, you see that I have managed larger units, and I had an owner who refused to do anything. It became a big issue, and I can walk away. A receiver, as he said, has a fiduciary duty to their court extension. A manager has a fiduciary duty per a contract. So when that owner refuses to do something and the manager walks away, you've got tenants that don't have a recourse until we've got something like this. I think one of the things that's going to happen because this is now in effect is that, especially in my practice, we're going to be doing more frequent inspections. And it's going to become more normal for managers and owners to do that because they have to protect themselves against tenants who refuse to report things because they either don't want their rent to change or they caused an issue that they don't want it to be discovered. That could potentially put an owner in a situation where this is going to become an avenue that has to be addressed. I think that the receivers becoming the managers with the ability to make change and do something is the best part of this. When I had issues with the complex that I managed here in Carson, there was just a flat out refusal to address the issues. And so this is I think it's a great thing. I think I'm more here to answer questions about how do we get to this? Because as you said, this is kind of this is very serious. It's not just, okay, they're not taking care of this, we're going to the county. There's a definite process lined out before we get to that. And I think that's where the best part of this is in that process, giving the owners and landlords opportunity to address it, and then having an option if they are refusing or like we said, dead. So I'm happy to answer any questions, and that's, I think, why I'm here. There you go.
Great, thank you so much. That's great. Those are great points. Thank you again to all of our panelists. I did have one. I'll sort of kick us off if that's okay, and then we'll go. Maybe we'll start in the room and then go online. And maybe I'm sort of putting Red on the spot. I told you I wasn't going to have any prepared questions, but I'm going to do it anyway. Sorry. Do you have, and mostly it's because your presentation made me think of it, and you just have so much experience in this area. Are there some, if you could think of like one or two, like pitfalls for local government in this process when they're doing it? Are there just some things off the top of your head that you would suggest that they just in your experience that like almost like a best practice that some folks could take away, and then we'll go to some questions.
No, definitely. I think one real practical suggestion I would have is that knowing when this receivership remedy is a potential tool and option for you to use, and almost more importantly, when it's not going to be a valuable tool to use based on the property. And so what I mean by that is we have what we're willing to do, and we'd be willing to do for any of your counties as well, is that when a property is getting to that point where you're not getting compliance, you're getting refusal or whatever, but it's just kind of you're running into that brick wall. Now that this remedy is available to counties, what I recommend people to do is they can reach out to someone like me, and we will give, in a day at most, we can give you a very informal kind of green light kind of assessment to say, yeah, this would make sense for the receivership remedy if that's a route you want to take. And so those considerations that we're looking at we'd of course be making sure does it fit the definition, residential, multifamily, rental property? Does it, is there equity in the property that would allow for any receiver to actually put together a budget, to actually fix the problems that, the county is suffering from? Because nobody wants, right? Nobody wants you to waste your time, waste your attorney's time putting together this beautiful petition that lays out just how horrible and nasty this property is, and even get a judge to go, oh my gosh, this property's horrible. It's a horrible situation. Get a receiver appointed. And then, you get some receiver that goes, oh yeah, this is horrible. Oh, by the way, I can't put together a plan to fix this. I don't have any money available. And so a big takeaway, a best practice is to ask a couple very simple questions. And again, I'm always happy to, informally answer those questions for you, to know even if at base level, it's going to even be an option for you. So I'll point something out. A lot of these properties, especially ones that are ignored for years or if not decades, they doing a simple kind of running a preliminary title report, or running it through if there's any county taxes or IRS tax liens on the property. That's going to tell you real quickly if it's got, let's just say any amount of tax liens that are at or above, what the property is even worth. A receiver's not going to be able to do anything for you. So that would be my best practice, is even if it's on the table as, hey, should we even consider the receivership remedy while we're trying to address this nasty problem property? Outsource the work to someone like me, because in an hour or two, we could tell you even if it's even an option for you. So that would be one best practice. And then I would double down on what I said earlier about imagining, with your code and your building official and your county council, envisioning the end moment that you're actually in court in front of a judge when you're preparing that petition to say, do we have real-time data that will be backed up when we're in front of that judge? Do these conditions really substantially endanger someone or the public or the neighbor? And did we really give that owner a reasonable opportunity to handle it themselves? Because judges will be laser focused on those issues.
Great, thank you. If it's okay with everyone online, I think we'll start in the room. Are there some questions for our panelists? We got Mayor, start with you.
So I'm very interested that if you take a receivership, do you see you've relocated 8 people in a complex or something? Do they end up coming back to the facility in reality, or do they stay where they were relocated? And then do you see large rent increases to be able to allow the owner to recover money to pay off this neat new debt that they have?
Maybe we could, let me think about how to handle this question. Maybe it's for Red, and then Joanna, I don't know, do we have a county perspective on this too from the panel? I don't know. I'll let whoever wants to handle this question take this one.
I didn't direct it anywhere. Yeah.
No, I know. That's why I was like trying to figure out where to redirect it.
Yeah, I'm happy to handle it.
Sure.
So as to the first part about kind of what we see with what I'll call is temporary versus permanent relocation. It's first off, I'd say it's really a lot of that decision is going to be up to the actual occupants themselves. Obviously, they're not bound to, they don't need to come back if they don't want to come back. But the statute does talk about they do have a right to come back. If they've been relocated temporarily, they have, in a sense, kind of a right of first refusal to come back if the owner does take back control of that property and reopen it to the market to lease that property. The statute does not restrict that owner or any subsequent owner to keep those rental rates at what they were previously. And so I believe that'll be somewhat subject to kind of just market pricing. The reality is, assuming those units were the problem that needed to be kind of addressed, they're going to be in more not upgraded, but just they're going to be finally safe and habitable, and that may affect the pricing of that rental unit. But the relocation, depending on, and this is going to be based on the facts of the case, sometimes if you're relocating folks from an apartment building and it's going to be a really, really extensive, large project, what you have are occupants that are really looking, again, their choice. They want to move somewhere else where they're kind of set up a little bit more permanently. They may not want to be in an extended stay, motel type situation if they've got kids in schools nearby, etc. So sometimes folks are looking to their relocation request, let's say, is going to be, well, we want first month's and last month's rent at a new apartment unit because we want to go sign and have some stability and have a year or longer lease. And so those folks, again, when I said it's up to them, they could be almost choosing for permanent relocation at that time. If it's a shorter, more precise project, smaller building, and you're really talking about relocating people for less than a month, our typical plan is they're going to go to kind of an extended stay, kind of motel suite type setup, and then be moved back directly into their unit under their same lease that was already in place, same terms, same rental rates, swiftly. And now I'm sorry, I know that was just the first part of your question, I think, but.
Well, I'm really just interested too, like in Carson City, I would say I don't have any facilities for them to relocate to.
Mm-hmm.
So we've had cases ourselves that we have gone in and done some remediations and some issues. And when we serve or shut down a location because it's not habitable, I don't have 12 units or 15 units or 20 units. I don't have anywhere to put the relocated person. And so I guess that's, what do you do as a receiver? And that's why I asked, are you getting them relocated to another community, to another, and they're gone. I don't know what to say, but we don't have any facilities. We don't have vacancies, right? Everything's full. What do you do?
Yeah, and you can imagine we see that all over California as well. And so I'll go back to that best practice thing I was talking about earlier, is that talking to me, early on. And if you called me, this afternoon and said, hey, we got this 12-unit building, it's pretty bad. You'd probably have to try to relocate 12 people. And oh, by the way, there is nowhere to put them. What I would be telling you is that, okay, here's some things that a receiver could do. I could fix that property. I could get those units cleaned up. I could get your property in compliance. But if you're telling me the truth is there's nowhere to put these people, well, then this might be a red light for you on that building for that receivership, because I don't have no receiver has any magic place to put them. And so, but being open and direct about that early on, it's only going to best serve your county or your city, because you don't want that to come up after all the work of getting someone like me appointed, and then I go, okay, now I'm going to go relocate these people, and then you're like, oh, by the way, we probably should have talked about this, but there's nowhere to put them. You know, that's sometimes can be simply a no-go, and that's okay. Now you're just going to go back to your other options that you may have to address that property. But at least you assessed, you know, the option of receivership and decided under these circumstances, based on the conditions of housing shortages right now, it might not make sense. But to your point, it's worth the brainstorm of, because I've handled ones in California where have a neighboring city who doesn't maybe have, you know, as many restrictions, at least at that point, on housing, and we can do a relocation there. We can slow down the project. Again, I'll use the hypothetical. If there's 12 units, let's say you have, well, gosh, there might be 3 or 4 units that are somewhat close by and salvageable. We've done a lot of projects where we phase out the relocation. So we kind of do, it's going to depend on the violations, but you can phase out the project. Okay, we're going to address 3 of the units first. Those 3 occupants are going to be relocated. Then when we get those units up into safe condition, we're going to move those people back in. Now we're going to move those 3 others in units D, E, and F. They're going to get relocated. So it definitely slows down the project. But again, under certain circumstances, that may be the only way that it works based on housing shortages.
It's a great question, Leander. Did you have something to add?
I do. If you move someone out and they're gone 2 or 3 months to do a rehab or under lease, you have the owner, manager, landlord has to go with the terms of the lease. So even if it was a $10,000 project and they were paying $1,500 a month, if they choose to move back in the property, they're paying $1,500 a month.
Whatever the remainder is on the
Whatever the
lease.
remainder of the lease, and then proper notice would be given of an increase. And, you know, if the landlord doesn't have to just eat this cost, it can be passed on, but as a new term at the end of the term of the lease.
Does the time that they're relocated toll the contract? You know, like I have a year contract and I'm 7 months in and I relocate, does that toll it to the moment they relocate? Or tough luck, you were 3 months gone, that's now 10? There's 2 months left. Does that make sense?
I'm not sure.
So I have 5 months?
No, so
Right.
because your contract, right, so if I signed a new
Right.
contract January 1 for 12 months, the end of that would be January 1 of next year, right? So yes, if
So
you,
no tolling,
yeah,
Right.
so it does not pause
right?
your lease while you are having to move
Right.
out.
No tolling. Interesting. Yeah, so they.
Yes, Hope.
Okay, 2 questions. The first is probably easy. Well, they're probably both easy. Okay, 1, can we use this bill on illegal RV parks? And secondly, we're in Carson City. Do we have receivers in Carson City? How do we find a receiver? Is there a licensing board for receivers?
That one open.
So the first question on the RV parks, I believe the answer is no, but I'll ask the folks who worked more heavily on the details. Joanna, I don't think you can use this for RV parks, correct?
I think really it talks about residential multifamily. There were some requests by legislators to maybe we should define that term. We resisted defining that because it can be defined differently in each county, right? So it's really this can be used for residential multifamily properties. So if that's how
It's a yes.
Oh, it's a yes for you.
It's a yes for
Okay.
this man.
So yeah, that's true. There
it's
was
how your
flexibility.
county defines it.
Your definition.
What we have,
And then Vince,
it looks like the
I'm
bill
sorry?
did not define the term, and you just mentioned that was intentional. And what I'm sure a lot of my colleagues have as well is folks will set up unlawful RV parks on vacant land for permanent housing. And there are significant health and safety issues there. And I'm going to say that counts as multifamily residential permanent housing, because that's the intent. Okay, and then so the next question would be, how do we find a receiver, and are there any in the northern Nevada area? And is there a licensing board that we can go to?
may I take a first stab at that, and then I'll defer to the rest of the panelists. So we do have receivers in Nevada. In the bill, we actually tied the ethical duties and there are other types of receiverships in Nevada for protecting like a mortgage bank's interests and creditors on a property, private loan transactions. So the Supreme Court already regulates and defines like they are the ones who oversee the qualifications for the receiver. It can be a lawyer, it can be a firm such as our speaker on the panel today. We also have the ability, and it really depends on the counties. It's not saying you have to, but like if you have a nonprofit the nonprofits can petition to be a receivership. It's also contemplated in the bill that a nonprofit or one who is experienced in this type of work, nonprofit or something, could also be appointed as the receiver, but they have to make a showing to the court that they are qualified and can manage all of the work of the receivership that Red outlined today. But so that's really the piece. There are people who are doing this work today in different types of transactions that are in place. And I know that there are receivers in neighboring states that also have been watching this. So I bet that there will be opportunities, and I'll defer to the rest of the panelists as well.
Does anyone else have any add to that? I do want to go back to the RV park piece and the residential. So there is a definition. Jim Rodriguez was kind enough to bring over your bill. Section 6 defines residential multifamily rental property in this bill. It means the bill 211. So it means a parcel of land in an unincorporated area of the county which is primarily used for personal, family, or household purpose, to which is affixed 2 or more dwelling units for occupancy by a tenant based on a rental.
Yeah.
For me.
Section 6. So there is a loose definition there, so it would not,
It's loose though.
Yeah.
Yeah.
but it doesn't seem to, but okay.
So what we resisted was like definitions on like certain numbers of units or those types of things that
Yes.
have been in other legislation in the past. So thanks for that clarification.
Yeah, you bet.
I just had something to add to Hope's question, part of it was mine too. There is.
Sorry, who are you with again? Sorry,
With the Central Nevada Health District.
Okay.
I was just curious, is there any licensing for the state of Nevada or training or standardization for receivers here for the state, or are we accepting out-of-state receivers, and what type of licensing do they have?
I think, sorry, if you are not speaking, could you please mute? Thank you. So, Red, can you talk about how the receivership is picked? Because I think that would be helpful.
Yeah, yes, no problem. So
Thank you.
In California and in Nevada, there is no formal list. There's no kind of court list of receivers that have met some sort of qualification. So just as in California, similar in Nevada, any receiver, any individual can be proposed as a receiver by any party in a case, and it's going to be that individual receiver's qualifications that are proposed and presented by any party that a judge is going to consider. So there's no license. You can be a lawyer, you can be a non-lawyer. At the end of the day, it's going to be the specific qualifications to say, hey, maybe they've done this before, or here's their experience with this type of property. They don't have to be in state. They can be out of state. Awkward, shameless plug. I'm certainly ready and willing to act as a receiver in Nevada. So no, there's no formal licensing or kind of approval process. It's a case-by-case judge's discretion procedure.
Right, thank you. I think that would just be helpful for everyone to know.
That answered my question.
And I'm going to go to the commissioner here in front of me.
Yeah, my questions, maybe, I have three, maybe two of them go together. As we know, in the state of Nevada, we have a public administrator that takes action when someone dies that has no will, probate, or estate plan, or family that lives in the state. So when we have a property like this, and that's the case, wouldn't the court or the county just like, hey, public administrator, here's another job for you? Handle it, call us when you're done. And then if they're not dead, when you put up the duties of the receiver, they were almost identical to the duties of a public administrator in the state of Nevada. So would the county or court be better off, because they already know what they have with the public administrator? Would they be more out to just appoint that public administrator to the duties of that to handle that situation? So that was something I was thinking. And then my last question, I guess, would be, you spoke about the receiver going in and obtaining a loan. Well, who's giving the loan? Is it the county giving the loan? Because you don't, as a receiver, unless you're self-funding the project, I'm the bank, I'm in real estate development, I know I'm not gonna give you a loan because you don't have any touchings to the property. So I found that to be interesting. So could you expand on how a receiver could get a loan to make the repairs? Thank you.
So I'm happy to take. I could take all of them. Anyone, feel free to jump in if they want any of this. Public administrator issue, and what I would say is that's fantastic. I would consider that another tool in the toolbox of any county. And if the court system and the county administrator's office is ready and willing and able to jump in and handle whatever the violations are of the property, go with that. And this is not a either or one's better than the other. If there's a well-suited, experienced public administrator that's ready to take these on and handle the problems, fantastic. So I'm not here to say one's better than the other. This is just another tool in the toolbox, I'd say.
Yeah, let me interrupt there. I think to that point, we shouldn't be circumventing existing processes with this. The public administrator certainly handles the students' estates, and that should be the case now.
Okay.
Yeah, I would argue. So, sorry, go ahead. Not to interrupt.
Yeah.
Continue.
No problem. And then to kind of give some background on the receivership certificate, so the loans. So the court, through the statute and then through the actual judge who grants the receivership, what the judge allows a receiver to do is the receiver steps out. So I'll just use myself. It's a better hypothetical. So if I'm the receiver, I go out and I act as the borrower on behalf of this property. So I go to private lenders. I go to private lenders who look at the property. And again, it's going to be qualified based on the value of the property. And a private lender is going to fund the money to the receivership estate, and their loan is going to be secured by the actual subject property. And the terms and the identity of that lender are all going to be transparently, presented to the court and approved by the court. So that's the kind of the funding mechanism.
So can I ask one question?
Yeah, please.
So I understand the private lending. I'm in that every day. If there's already a mortgage on the property and you go get a private lender to get a mortgage on the property, who's in first position?
Right,
Because if I'm a private lender also, I'm not gonna be in second position.
right.
So how do we achieve getting first position?
Yeah, so that's a really, really good question. And so in California, the case law establishes that in a health and safety receivership certificate loans, with the discretion of the court, a court can authorize that receivership loan jumps in super priority, jumps in first position in front of any other private lenders. Now that has to be court ordered. And you can imagine any other, lender, any loan on that property, that lender has to be served with notice. They have all the due process rights to go in and argue to the judge that they should not be subordinated. And so that's you can imagine a thorny, opposed issue, a hot topic in California law and receivership law. So given that this statute is 3 months old and there hasn't been an attempt yet to get a receiver appointed, that's probably an issue to be addressed at a later date in front of, a judge. So again, back to that kind of best practice. If any county in Nevada came to me and said, hey, here's a real tough property, we're thinking, I don't know, is receivership a route? We're gonna pull an informal property profile and understand what the liens are, private and potentially government, county, IRS, etc. And we're gonna say, look, it's a apartment building. Let's just say it's arguably worth $1 million. They already have a private loan on there for $500,000, and this is going to be a huge project. I'd say, look, I think if you're being conservative and you're trying to decide if a receiver can come in and borrow a bunch of money and fix up the property, you got to play out the scenario that a judge may say, great, receiver, if you want to go out and borrow some private money, but I'm not subordinating that existing private lender. So if you got some lender who's willing, on their own underwriting guidelines to fund some money, it's going to be in second position. So, or, hey, county, you can go in there and go into court and also make the next leap and make the ask that the receiver's loan be in priority position over that existing private lender. That's I don't want to say a gamble, but that's just something you're gonna have to weigh out, pros and cons. You might find yourself, and I always play out worst case scenarios, you may find yourself the judge uses his or her discretion and says, no, not going to subordinate that private loan. So yes, there's case law. The case law is actually like the US Supreme Court level. So there is case law to argue that a receivership loan, there's the discretion for a judge to put it in first position. But it certainly hasn't been, tested out in Nevada at this point.
Thank you.
Can I pop in on this one? Just
Yes,
a little
please. Go ahead.
bit. Thank you. Because I know we're everyone is talking about the receivership. That's the whole point of this. But I'm also looking at this conversation and the previous one about opportunities to have all of those discussions before it even gets to the point where, we're going to court looking for a receivership. These are all things that can be fleshed out, that can be, if there's communication with the owner, how all of these things play in, whether or not the owner is aware that, hey, if you don't fix these things and this goes into receivership, these might be all of the other things that you're facing. So I know these are really valid questions and things that I haven't thought about before, but I also just want to bring back that there's so much time that we tried to put into this that it never gets into a receivership. The goal is compliance. That these are really good questions, but also should be tools that counties have before it even gets to that point.
Yeah, that's right. Thank you. Okay. Yes, sir.
I got one. So you had mentioned that Clark County has an abatement budget and the property that this was kind of initiated over, would still exist. So could a receiver go to that abatement budget and say, hey, you have $75,000 in Clark County's abatement budget. We need $60,000 of that to fix all these issues to bring it into compliance? Or is there something in this that says, sorry, the county's money is for the county and it's on the owner to fix this?
That's probably a question for Joanna.
This is Joanna. I think throughout the statutes, and I'll have to, I'm going to go back and read on we didn't contemplate, when I mentioned our abatement budget, I guess when I talked to my co-director, it was the reason why we wanted to seek this as an additional tool in Clark County, I'm just going to tell you why the abatement budget wasn't sufficient for this, is that we was just a volume issue for us, that yes, we have a robust abatement budget. But this is what my co-director would not seek this if he can use that. That's really what he's doing. And the challenge that we saw, and we talked about the public administrator, and that's the challenge that we saw in Clark County was we had a very, very large and multiple large complexes that had fires and calls to service from Metro, all of the things that were happening, and that it was hitting our social service budget to have to relocate large amounts of people during a time where we also, the mayor noted in Carson City, you don't have a lot of resources, that was really our issue on that. So we didn't contemplate that the county would be responsible for paying. And over is how this works is that the costs are really on the owner of the property to the fullest extent that it can be, because this is a responsibility of the property owner. So that's and that we wouldn't, just to address the public administrator issue, is that really our issue was where there were very much landlords that were alive that were maybe out of state or not responsive to code enforcement. Is not something that that we also have a public administrator that can step in on that piece. And so that was the answer. I don't think that we would seek receivership from, I'm only speaking for my county, where the code enforcement could use that abatement budget and we could do it ourselves. When we were working on this bill, we worked on it for multiple years, because what we found was like, is there a way that the county could manage this, right? But we're not in the business of property management. We rely on people like our speaker here on the private sector, on the property management. We didn't feel like we had the tools to step in and manage properties, and that's not the role of the county code enforcement. So the abatement budget is different, and would be used before we were to seek this, and that's really how we're planning to implement it, if that makes sense.
Thank you. I think we have time for probably one more question. Does anybody else online have a question? All right. You have one more in here? Yep, go ahead.
So if the county expends funds for a property, can we put a lien against that property? So if it ever was to get sold, we can get our money back?
That's what we do.
Thank you.
Yeah. Sounds like you have some work to do when you go back to the. Sorry, I didn't know that. All right. Again, I want to thank our panelists, Assembly member and everyone else that joined us. And thank you very much for joining us in person. I hope you found the information useful, and look for the next NACO workshop next quarter. So thank you very much. Thank you all to our panelists as well. Have a great weekend, everybody.
Thank you.
Thank you.
Sure. Okay, you're welcome. We thought